Thank you, Your Honor. The authority that the department operates and uses under Atwood is ministerial. It is delegated authority. The chapter is controlled by Department of Safety. The Commissioner of Safety, Jeff Long, enforces and administers the chapter. When I say that the Commissioner of Revenue has ministerial authority, that is because his position in that law is step and fetch it. Every act he does is under the authority of the Commissioner of Safety. He does not have independent authority, and he does not have an independent program to revoke me or the large body of people who are revoked every year. It's 112 criminal convictions a day. My filings give the number as 12. The correct number is 112 per day out of the 40,832 total convictions per year in this program. That's the average figure. His authority is ministerial, and the Commissioner of Safety provides due process. The Commissioner of Revenue does not need to provide due process. I haven't gotten it in my hearing because of the lack of authority by the lack of authority of the judge to hear the matter. It's a ministerial authority in revocations because these revocations are these licenses. The Commissioner of Revenue has this ministerial authority without discretion because the people he's adjudicating over or administering over have already had their due process. They've had their due process in safety under 103 and 104. In this program, the Commissioner of Revenue is given the authority to supervise using EVIS the people who have to have POFR. It's a supervisory role. It's as like someone who is a probation officer. Probation officer wasn't involved in catching the offender. He simply is administering the sentence. The sentence comes from, as I'm explaining, safety. You have to have, on condition of the privilege, insurance for however long the suspension is. Then you're released. So these parties, as my flow chart shows, my flow chart explains how all these parts work. Safety issues the orders. Gerregano in Revenue takes the orders, and when he's given charge of someone to give a 210 notice to, that person doesn't have a right to a hearing. He doesn't have a right to a hearing because he's already been adjudicated and administered as a party liable for performance for a unpaid judgment or a motor vehicle conviction or some other motor vehicle related offense. But he gets to keep his privilege for his necessaries and just maintenance of life. He gets to keep the privilege on this condition. And that policy that he has is not just your average ordinary operators or owners policy that you have or that I have, perhaps. It's a different policy. It's one that's in the statute. The revenue people are saying, well, it doesn't matter. These are all the same. And so I really can't get relief in revenue. Again, because of the statutory instructions for the hearings being in safety, the system is not set up to give me relief. And if I have a right to relief in revenue, it has to be before. I would say it's general jurisprudence in our country that you have a right to be heard before execution, not after. And the statute does refer, 67-1-105 does refer to proposed revocation. Well, I have a right to, under my rights, under our Constitution, the right to be heard. I have a right to be heard before the harm is done to me, before the controversy is decided and I'm left to clean up the mess. I have a right to a hearing beforehand. That's called due process. Because this program is arbitrary and capricious, it is a workaround of these people to say, well, we can authorize that under the tax law. This is not a tax law case. This is not a case that comes under that statute. It comes clearly under the TFRL. And I can't get due process. I can't appeal to safety for relief because safety has not sent me any notices of revoking anything. As you say, revenue is responsible for registration, Title 55, chapters 1 to 6. It's all in revenue. But again, it is a ministerial function. The only authority that's independent of safety that revenue has is when there's a fraud regarding a plate. And then those people in that long tail of administration who have pictures of this in my motion for summary judgment. The long tail that lasts 3 to 5 years of people who have to have insurance. It administers them. They have had their due. There's no hearing. No hearing required. They don't get a hearing. They've already had their hearing when the law is properly run in safety. Regarding Mr. Barca's comments about the terminology not being exactly the same, that is an irrelevant and disappointing discussion in that footnote. I would say it's a kind of judicial delinquency that the commissioner is asking the court to take part in. We're talking in this law, in the Atwood law, about a narrow thing that's being enforced. It's very narrow. It's not broad. It's constrained by the purpose statement of the law. The purpose is, again, to verify whether the financial responsibility requirements of this chapter, there's no parallel program here, no independent program, of this chapter has been met with a motor vehicle liability insurance policy that's defined. That's defined at the very beginning in 102.7. And the people who are subject to supervision under the eyeball they've had their due process, and now they just have to use the road safely. They have what's called financial security. Their forward-looking policies secure future possible accidents. If they have a record of being irresponsible, they've been adjudicated and administered as irresponsible, that policy protects the public and it protects them, again, using properly the coercive privilege authority of the commissioner and of the General Assembly. This is a proper use of the police power. So the claim that the terminology changes, therefore the fact that the exact phrase, as he says, is not used, means that the commissioner can do what he wants. Well, my filings point out, and I believe I pointed out here, that the phrase motor vehicle liability policy is in Atwood. It's in Atwood, with the word insurance put in. Motor vehicle liability insurance policy. The Atwood version inserts the word insurance. Motor vehicle liability insurance added policy. That's the same policy, and the fact that it's not identical cannot be construed as allowing this barbaric program that gives the insurance companies, Your Honor, at least, in my guess, $2 billion a year extra in free premiums that they might not otherwise get. So we have here what is fair to call an industry capture, a corporate capture of this department. To the point regarding the UAPA limiting my right of appeal. That's not how the court system works. Under the Bill of Rights, I have a right to be heard, and I have a right to redress of grievances. And here I have a grievance that I've pursued for 2 years in good faith, trying to get the commissioner to look at what the law says. I lose, and now I'm being told, well, you can't target the program. Well, like Mr. Barca says, the orders, the final orders, the initial order and final orders are the things appealed from, and they support what's being done statewide and against me. Those rulings support the program. So the program rightly is in view for adjudication, the entirety of it, not just me. I'm not here just for my own tag restoration. I'm here in the public interest, and I've made that clear from the very beginning. This whole program is a degenerate abuse of the law by the commissioner. UAPA does not control anything now. What controls is the great chancery authority empowered by my petition and the record that allows the court to look at the whole situation. It can't agree to have the commissioner give me back my tag without looking at the whole. The whole can't be not addressed if I'm to get my tag back. I'm not here just for my tag. I'm here to end this program in the public interest. UAPA does not limit the scope, because if it did, that would say that you have seen in the agency, following the sovereign immunity requirements. I think that in Title 20 there's the rule that says how the state may be sued. And here, in this case, I'm suing the state according to the rules. I'm following the rules. The agency that offended me, I'm suing the commissioner in his agency to set the record, to make my claims. And now that that process is done, I can't be constrained by what UAPA says. And I hope you get a sense of how wanky the argument is about the stay. A stay is something, as I understand it, that stops something from happening. To argue that UAPA says, well, there's no right of injunction in chancery because you didn't ask for a stay. Well, a stay is irrelevant. A stay is not an answer. Why? Because the revocation occurred before that case began. A stay would somehow prevent something from happening. The thing that could be prevented by hearing before revocation, there was no view of that happening. It didn't happen. And so a stay can only apply to something that is about to happen. And the only thing that's happened since the revocation is words flying back and forth. So it is improper to suggest that that's a legitimate argument that I can't ask for relief against the whole program, because the whole program operated against me as it operates against every other innocent, good driver out there who may be poor and not have insurance. So UAPA, I think, is limiting the right of appeal, I believe, is improper and wrong. The commissioner emphasizes in his filings and even here the qualifying accident scenario. TFRL looks two ways. It looks backwards and it looks forward. Now, the part that the department is looking at is the rear-looking, backward-looking qualifying accident and how a party like me, uninsured, would show financial responsibility. If I'm uninsured and I cause an accident or I'm involved in an accident, I can comply with the statute by saying, well, I caused $6,000 in damage. I have an affidavit that I'm submitting to the Commissioner of Safety, and he has to accept that, unless there's some reason that he shouldn't. And so people without insurance can participate if they drive more vehicles in the statute. They're subject to the statute. If that crash passes $1,500 and they're in a vehicle, they have no choice, but they have to comply. And so here, in the way the law is written, you have uninsured people complying with the statute. But the commissioner, when he finds them at some point with his data mining program in EVIS, he's going to revoke them. I mean, here they are complying with the law, showing responsibility, and maybe the next day they get a letter saying you don't have insurance and we're going to revoke you in 4 months if you don't get your act together and buy the product. The emphasis by the commissioner on this part of the law, the backward-looking part, doesn't look at the forward-looking part, which is the bulk of my analysis. What you've heard from me today looks at all the provisions dealing with the certified policy and how people who are subject to Commissioner of Safety become subject to the requirement for insurance, the POFR requirement. They become subject to it because of actions of theirs. And just look through the provisions. The Some at the beginning deals with the qualifying accident, but most of it is administering the corrective action, which is what revenue manages with its part. Of course, it manages just the tag, and always under orders, not independently. So again, about the commissioner's authority, he has authority to revoke unilaterally people in the system under EVIS requirements because they have failed to do what they agreed to do. They agreed to have insurance. Hey, you have a motor vehicle liability policy. You have a certificate. Revenue has, safety has the certificate. We know you have the certificate because the policy is identified that way in the database. And you're not keeping up the payments, so now you're going to get the first notice. Again, that's a ministerial revocation if it happens in the 4th month. It's not discretionary because the Commissioner of Safety has already looked at this case and has already made a decision, and it's all set. So that's why it's ministerial. I'm glad Mr. Barker did not go at length about legislators' opinions. They are, and their quotes from the floor, the well of the House or Senate, they don't have bearing, and the reason they don't have any bearing, as the case Barnhart versus Sigmund Coal Company points out, and that's 534 U.S. 483. It says, as in all statutory construction cases, we begin with the language of the statute. The first step is to determine whether the language at issue has a plain and unambiguous meaning with regard to the particular dispute in the case. And it goes on to say, the inquiry ceases if the statutory language is unambiguous and the statutory scheme is coherent and consistent. What we have here is a complex and prolix law. It's very, very complex, but it's not ambiguous and it's not unclear. And yet the department has continually brought this up. It brought in the very end of the case in the agency, the audio files of Representative Lamberth and others saying what they wanted, as if that somehow controls what the actual words say. And I think the actual words of this statute are, as I'm describing them, in particular, that the operation in the department is arbitrary and capricious. The commissioner points out that there were, when the General Assembly was concerned about this and passing 139, there were 23% uninsured. Well, we now have 21% uninsured. So the program can't eliminate uninsured people. It can't. It won't. And that's because at least 1 in 7 or 1 in 6 people are poor, and they're electing to buy groceries and pay car repairs and daycare bills and heat bills and the like, and they just can't afford that product. The commissioner mentions State versus Booher. He says in his presentation that I'm claiming that I have a constitutional right to operate a motor vehicle on the highway. I would never make a claim like that. And the reason he makes that assertion is because the people in that department don't recognize the difference between public and private, between taxable and non-taxable, between privileged taxable activity on one hand, and private free activity on the other. And the commissioner being in charge of the tax system, not seeing the distinction between a privileged act and a non-privileged act is very concerning to me. And I have resisted it as much as I could, trying to explain using Phillips versus Lewis, the 1877 case, I guess the most magisterial of all the privileged cases that explains how it works. Booher, in fact, points out that state regulation of the use of the road does not implicate private travel. Driving and operating a motor vehicle is a privilege. It is privileged taxable activity for private profit and gain using the people's roads for that private profit and gain, which no one can do by right. There's a principle of law that, in a case that I don't think I've cited, that says if it were so, it would be an unjust taking on the people as a whole. For a trucking company to make their private profit on the people's roads with 40-ton trucks pounding away at the pavement and causing dangers with weak brakes and large vehicles that are slow to slow down, that would be an unjust taking. So they have to be under privilege. The privilege system regulates them in your interest and in my interest. And so I would never make that claim. And the point is made by the commissioner that, well, in fact, Mr. Buchanan quotes, he doesn't quote Booher, but he cites it to say that, well, we all know that driving and operating a motor vehicle is a privilege. Well, yeah, of course it is. But since when does the existence of a privilege like that prevent a person from using the road for private purposes? And most people don't know the distinction between public and private use. They all think, well, I have to get a tag because I'll get arrested if I don't. And so they get the tag entering knowingly by law, as a matter of law. They know they're entering into commerce. They're going to the Department of Revenue for a registration, which is described in one of the early chapters of 55 as a privilege. Having a car registered is a privilege. Why? Because you intend to use it in the privileged capacity. And Booher's right that in that one part of the opinion that regulation does not implicate private travel, and that's what travel is a large category, Your Honor, and transportation is a subcategory subject to regulation, taxation, and control, and supervision by the troopers. The troopers have the authority to regulate and assist both revenue and safety in the collection of taxes and fees and looking out for the public safety. So this is an unjust use of that law, and it's being not law. It is an unjust use of that court opinion from 1977 to justify a program that effectively bars under threat of future criminal prosecution more than 1 million people, like me. And it's easy for the lawyer and the commissioner, who's a lawyer too, to say, well, just get insurance. Well, I can't get insurance, for one. And number two, that would be terrible legal advice. If I got insurance, that would be used against me to say, well, look, you bought insurance, the case is moot. Why moot my own case? I mean, that they would offer this kind of discussion is disappointing. It's just disappointing. As for the billable hours, I'm keeping track of my hours and what I'm doing in those hours. I represent David Jonathan Toulis in my case, and I'm the man, and David Jonathan Toulis is the entity, the person, is a legal person. I'm going to collect what's due to him, and the 822 hours, and the time, the billing that it may go past what the statute would allow for it. But this is not. I'm not asking for compensation. I'm not asking for damages. It's just my legal fee in service of this cause, which happens to have a version of my name on it. And so this is not anything grubby. It's not anything unjust. It's not anything pernicious or wrong. And I would like to ask you, Your Honor, what's the biggest problem you see with my case?
Well, I don't think I can answer that right now. You mean the merits?
Well, the merits of my case, which supports,
case writ large?
yeah,
I've
which,
not gotten there yet.
well, okay, but the merits of the case are part of my injunction motion, which is the clarity of the law and the certainty of prevailing.
Yes.
Do you have any questions for me that I can answer here or that might prove helpful to you?
That's a different question. Okay.
Yes, sir.
Yes. Mr. Barca mentioned this is the third lawsuit on this issue that you brought.
Yes, sir.
How did that happen? How is this the third lawsuit?
Well, this is actually the first one.
Okay.
This petition, the case was filed, my petition for judicial review, my petition for a contested case was filed in July 2023. And since that time, realizing the problems involved with the Commissioner of Safety neglecting his duties, I sued in Chancery both commissioners for fraud, the same arguments. And the problem is that Jeff Long is not fulfilling his duty to oversee Gerregano. So that's one case. I filed a federal 42-1983 case in federal court in Nashville. And that case is on hold under Younger doctrine. So, and that's because my federal rights are being offended. And in that matter, I'm suing just Commissioner Gerregano.
Okay, all right. So they're sort of different. It's not the identical.
No, they're not the same case. No, but it's on the same problem that I'm addressing, sir.
Okay. I think that's all I've got for you right now. Thank you, sir.
Yes, sir.
Yes, sir.
Thank you, Your Honor. I appreciate it.
Mr. Barr?
Yes, Your Honor.